All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Welcome to the Arizona Court of Appeals, Division 1. This is cause number CR2 Hasey versus BMO et al. For your information, these proceedings are being recorded. Audio and visually, they are being recorded, and so you may even find yourself on YouTube in a couple weeks if the recording works. As you begin your arguments and approach the podium, please identify yourself and who you represent. Each side will have 20 minutes to present their arguments. Just a minute. Appellant, you may reserve a portion of your time for rebuttal, but you have to keep track of your own time. And the podium has the time clocks on it. We have read the briefs and discussed the case in conference this morning, so we're familiar with the facts. So you may begin.
Thank you, Your Honors. Good morning. My name is Jim Santos. I'm with the law firm of Jennings, Houck & Cunningham, and I represent the lien claimant, the mechanics lien claimant in this action, which is HACI Mechanical. I often refer to them as Hackey Mechanical. This is a case involving the Century Plaza condominium conversion on Central Avenue just south of Osborne. One of the primary issues that we raised in the briefs, of course, was whether or not the Arizona legislature intended there to be an exception to the mechanics lien preference priorities as put forth in the statute, and intended to allow equitable subrogation as one additional exception. Mike Holden and Barry Willits, who represented Whites, beat me to the punch on that issue, and in November of last year, the Whites v. Heth case came down, and it analyzed the legislative intent based upon an analysis of the legislative statutes and words that they used to determine whether or not the legislature was intending to create one more exception to construction lenders, such as the bank in this case. Although the Whites v. Heth case stands for the proposition that no, mechanics lien priorities are established by law, by statute. There was never the intent to add other exceptions. There is a petition of review pending in that case. I guess it's possible that it could be changed. So let me address still why in this case, under these facts, if equitable subrogation could be said to apply, it doesn't apply here. It helps just to kind of go back to think about what a contractor is, what a subcontractor does, and how they extend credit. Most people don't ever think of this, but a contractor or a subcontractor like Hackey is extending credit every day. They are doing work. They're paying their employees to show up on the job every day. They're buying materials and equipment to be used on the job every day, and they're paying for all this with the hope that in the future they will be repaid. Under the Prompt Payment Act 321129, it describes the typical procedure, and it was the one that's followed under the contracts that we see here. Hackey Mechanical would perform a month's worth of work. At the end of the month, they would apply for payment for all the work done in the prior month, the credit that had been extended. If it was lucky, during the subsequent month, they would be paid for all that work that was performed. And in this case, Hackey Mechanical has a $2.6 million prime contract, or rather subcontract, to do the work at this condominium tower. They receive
is that the amount their lien would be, counsel?
No.
What is the amount of their lien that they would, that's at issue?
The net of any less payments. So they had a $2.6 million contract. They received payments of roughly $2.4 million. The lien in this case is a little over $186,000.
Thank you.
Now, with this extension of credit, the legislature has created a method by which the contractors can secure this extension of credit, and that's through the mechanics lien statutes. So after having extended this credit, $2.6 million of credit total, after having received partial payment of that, $2.4 million, there remains a balance of about a little less than $200,000. This credit is secured by the real property and the improvements that are built on top of that property, and the priorities are set by statute. Construction lenders, such as the bank, they have the ability to become first or come behind mechanics lien priorities, and they have the ability to either not loan or to loan money, depending upon where they might end up in priority. Judge, you
I was just going to say, so that the bank's election at that point is based solely on the timing of when the construction loan is put in place?
that is one of their elections, certainly. Most lenders would, well, in the old days, they would send someone out there at the property and look around and see whether or not anybody has disturbed anything, any dirt has been moved or anything like that, and if nothing has been touched, no construction had begun on site, then they would authorize the recording of their deed of trust and make the loan. The legislature in 1998 gave them a 10-day buffer for that, so they didn't have to, because after all, on their way to the recorder's office, someone might put a spade in the ground and start digging a hole, and that could actually violate or avoid the priority that they were hoping to achieve. In this case, the bank made a loan months and months after construction began, so it knew where it would be in priorities to mechanics liens, if there were any mechanics liens at all, and most jobs.
Part of that loan was to take out or satisfy the original deeds of trust on the property? The
owner who borrowed the money used part of the money borrowed to pay off a pre-existing deed of trust. You're right, Your Honor. And it was required of the owner to do so. And the owner was required to do so out of the funds the owner supplied or that the owner acquired by the way of this loan. And we know that the owner supplied $2.3 million to the escrow at close. So how much of the bank's money was used? They haven't said, but it doesn't matter. Not on a job where the end result is that the project is worth over $20 million. They could have if they were entitled to equitable subrogation, they could have a $6.8 million equitable subrogation lien, have a $4 million equitable subrogation lien. It doesn't matter because the value of the property is so great that there is no circumstance under which the bank would not recover at least $6.8 million. And in fact, in this case, when the bank filed its answer, the record on appeal number let me see here, 114, the bank had already, that was 19 months after the bank took title through its trustee sale, and some 16 months after it had sold the property to Lexington for $16 million. So at the time that the bank filed this answer, and then almost a year later when they filed their motion for summary judgment raising for the first time equitable subrogation, the bank had already received $20.5 million. So, if equitable subrogation is there to make sure that the equity the bank created by having some of its funds pay off a pre-existing lien, a $6.8 million pre-existing lien, as long as the bank gets at least $6.8 million, equity is satisfied. Here, at the time that the bank filed their motion for summary judgment, the bank had received $20.5 million. And the bank didn't tell the trial court this. The bank came in seeking equity, but rather than showing its clean hands, it kept its hands in its pocket. It, in fact, denied that there was any evidence in the record at all. On several occasions, told the trial court, there's no evidence in the record that we've received $4.5 million from the sale of 15 units. There's no evidence in the record that we made a credit bid of $11.1 million at our trustee sale. Well, it's there. And on appeal, thankfully, they didn't bother to make those same assertions. In my statement of facts, I listed every document where all these numbers are found. And in the response, they didn't bother to contest any of those facts. So I believe now we all agree that the bank was sitting pretty with $20.5 million in its pocket when it came to the court for the first time and claimed it needed equity. It needed equity to make sure that Hackey Mechanical would not take advantage of the $6.8 million of equity created in the property. Well, again, they've already received the money. So under these sets of facts, it just doesn't make any sense. Plus, you got to remember that every day Hackey was extending credit, the recorded documents show that there were no liens that would have priority to the mechanics lien. If you went down the recorder's office, you would see Sir Mortgage, the prior deed of trust were released. You would see the bank's August 2006 deed of trust was recorded, and you would see nothing of record that would give notice to anyone extending credit that there was some sort of secret lien existing. And the restatement that the court's always been relying upon every time we look at this statute, and I know Judge Winthrop, you've looked at this well in Source Corp, which was affirmed on by the Supreme Court. I know Judge Orozco, you've done the same thing in Brimmett. That, by the way, thank you for that decision. I was predicting that they should apply the payments that they received. I didn't have a decision to cite, and now of course I did on appeal. But in all these decisions, when there's nothing of record to give notice to anyone extending credit, that someone would jump in front of them, equity is not allowed. There's a comment to the restatement that describes that, and it talks about how we should not allow people to have secret liens to jump in front of people who are extending credit. Now, I know that the bank has claimed, well, Hackey didn't prove that they relied upon the record, the recorded documents. But, we all have constructive notice of everything that's of record. If we can be punished with that constructive notice, and by the way, people have been sanctioned for having recorded an invalid lien under 33-420 for a lack of notice or lack of knowledge of something that was of record that the court gave constructive notice to them of. So if we can be punished by constructive notice, we also should be able to benefit from the constructive notice that at the time the work was being performed and the credit was being extended, there were no liens that would have priority in this case. But again, it doesn't matter. $6.8 million. As long as the bank gets at least $6.8 million, equity is served, the bank gets $20.5 million. In its brief, it also raised some other issues. I want to briefly address those as well. The bank claims that our mechanics lien would be invalid for a couple different reasons, and it's not well thought out at all. One of the reasons that the bank claims our lien should be invalid is because we used the meets and bounds legal description. They attached to their statement of facts as exhibit number 1, record on appeal number 111, the legal description they claim should have been used. Well, that's a multi-page document. On page 1 of that multi-page document is found a little section called legal description. And underneath that title, legal description, is found a meets and bounds description of the property, exactly the same one that Hackey is relying upon. Hackey didn't actually set forth a legal description in its lien. It instead referred to a recorded document, as it's allowed to do under ARS 11482, which allows someone to refer to another document. If a legal description sufficient to determine the physical location of real property has been recorded, then a reference by record to that instrument is good enough. So the question isn't what legal description do we use, is did we refer to a legal description that was sufficient to determine the physical location of the real property? And the bank has never argued that it was not. The bank has claimed that there was one and only one legal description that should have been used at the time. And it's funny because you have another sum of builders case coming up on appeal, not necessarily the three of you, but it's pending in the Court of Appeals right now, where the bank's one and only one legal description that they said should have been used, when Summit Builders used it in their amended lien, they claimed, you didn't use the right legal description. If you look at record on appeal number 69, the bank argues that the only legal description that has existed since August 8, 2005 has been the 154 specifically listed condominium units of the condominium replat. Well, since August 2005, the only legal description is the 154 specifically listed condominium units. The bank's deed of trust recorded in August 2006 didn't list 154 units, didn't list any units at all. Actually, there was 160 units because during construction they reconfigured the place, which is why you'll see the bank sometimes talks about there being 134 units that it's sold to Lexington. Then on other occasions they correct that and say it was 145 of the units that was sold to Lexington. In SK Drywall, Supreme Court decision where they approved the single project, the legal description used is the meets and bounds. There was no allocation of unit by unit, either in price or in description of the legal description contained in the lien. You don't find that information in the Supreme Court decision. You have to go back to the Court of Appeals decision to see that. But that's the type of legal description that Hackey used. No one has claimed that it was not sufficient to describe the location of the property. It is the legal description found in the Sur Mortgage Deeds of Trust, which the bank claims when they were doing their secret trustee sale of the Sur Mortgage Deeds of Trust, resulted in them obtaining title to the 145 units. Those are the same units Hackey's lien should be attaching to. If the bank can claim that they used the Sur Mortgage legal description, which listed Century Plaza as the owner, listed the meets and bounds description of the property, and that was sufficient to allow them to gain title to the 145 units they sold to Lexington, well then Hackey Mechanical should be able to use the same owner and the same legal description as well. The bank also has raised the issue of whether or not there's blanket liens. Just to go through the history of it, the Northwest Federal Savings v. Tiffany case in 1988 said there was nothing wrong with a blanket lien. In the Supreme Court in SK Drywall in 1991 followed that up with saying single project, single liens is generally approved. And again, that was a lien that didn't allocate among the condominium units at all. They did allocate among buildings, but they had 11 different buildings. Here we have one building. We didn't allocate it other than the one building in the Hackey lien. Followed up by the 1994 case in CS&W. That's the Supreme Court case where they again said, no problem with lack of allocation. The court will equitably allocate the lien if need be. So there really isn't a problem with this blanket lien. The bank has claimed that we should have liened the 15 individual unit holders. Well, we didn't. We liened Windsor Century Plaza's interest in the 145 units it was still owned at the time the lien was recorded. Those unit holders all have said that they intended to buy their units free and clear of any liens. The owner intended to transfer it free and clear of any liens. I take that as their agreement that any payments that were already made to Summit, then to Hackey, must be for those units. And since we were only owed a small amount, the balance is owed against what was still left in Windsor Century Plaza's ownership, the 145 units. And our lien is the reasonable value of the work that was performed at the time we did our work. And there's no proof otherwise that that's not a reasonable value. How this should have been done, I think what should have been done is the court should have allowed us to foreclose their lien. The court could have protected the second lien holder position by authorizing them to make a credit bid of their own value over and above the Hackey Mechanics lien value of about $186,000. Under ARS 12-1562, the share sale can be done as directed in the judgment, so they have protection. They would not have to come out of pocket and make a cash bid themselves to protect their own interest, and they would have been able to acquire clean title or protect their interest to the extent they still had any. But all that presupposes that they had some sort of risk. They had already received the $20 million at the time they came to the court seeking equity, and they didn't tell the trial court about that. They were embarrassed to even mention it. They claimed there was no facts in the record that would support that. Your Honors, I'm going to go ahead and reserve the remainder of the time if there's any particular questions.
Okay.
Thank you.
Thank you.
May it please the court, my name is John Egbert. I represent BMO Harris Bank, formerly known as M&I, and in the pleadings and the briefing, it was referred to as M&I, so I'm going to, unless that causes confusion, we'll keep with that. Wanted to first address the status of where we are with this legal issue about equitable subrogation in light of the recent White's decision. White's is not binding on this court in the sense that we now have two camps. We've got Peterman Donnelly, we've got Lamb, and even Continental Lighting, which is a related doctrine of replacement related to equitable subrogation. All those cases say, yes, those do apply in the context of mechanics liens. And now we have the White's decision, which says, no, that's wrong. And so now you are going to need to decide, unless, again, the Arizona Supreme Court decides for us that which of those two views is correct. And we would submit that, well, first of all, counsel's right. Their petition for review is pending. Last week, we were granted leave to file an amicus brief, which we've done that. There's other amicus briefs that have been filed, and we expect that, given the conflict between the different opinions from this court, that there's at least a fairly good likelihood of the court accepting review. And so hopefully we'll have some clarification. But let me talk about why it is that the Peterman Donnelly, Lamb, and Continental Lighting cases are correct and White's is wrong. One thing that is very significant in the White's decision, it does not address at all the concept, the very well-established law that when you're interpreting a statute, that unless that statute, the legislature clearly intended to abrogate common law, it should be construed consistent with the common law. Here, counsel relies on a provision in the mechanics lien statute which does nothing more than say that a mechanics lien has priority over all subsequent liens. That was the law back in when Peterman Donnelly decided the case. The only things that have changed that they point to, the 1998 amendments, they don't affect that basic principle. That principle existed clear back in 1965 when Peterman Donnelly. And by the way, that principle is nothing more than the common law principle, that prior liens have priority over subsequent liens. That's common law as well. So there's nothing in Section 992A, which they rely on, which gives any indication that when the legislature a long time ago said that mechanics liens are going to have priority over all subsequent liens, that they intended to say, we're adopting this concept from common law, but we're not going to adopt equitable subrogation. Peterman Donnelly addressed it for the first time, quoted from the very language that they rely on from the mechanics lien statute, and were unfazed. Said, notwithstanding that language, equitable subrogation applies in this context, in the mechanics liens context. That was then reaffirmed in the Lamb decision and was again reaffirmed in the concept again in Continental Lighting. But I want to point out that the White's decision does not grapple at all with that requirement that statutes be construed in a way that is consistent with the common law unless the legislature clearly manifested an intent. It's not going to be implied. The Supreme Court has repeatedly said we're not going to imply the intent to overcome common law from just mere implication. It's got to be said. And that was not said in the mechanics lien statute. So we think White's is wrong, and we think that the equitable subrogation concepts do in fact apply here. Now let me talk about why equitable subrogation makes sense in this context.
Well, before you get to that, why doesn't it apply? I can really see how it applies to the first. I think it was 6.750.
6.8 with interest.
$8 million with interest. I can see how it applies to that, but why does the rest of it? Why is it all equitably subrogated? Okay, that's real. It's not equitably subrogated. There is no dispute, Your Honor, that we were entitled when we paid. We did our loan, and that loan, those loan proceeds were used to pay off the prior with first position loan that we were then equitably subrogated at that time. By the way, we weren't equitably subrogated when the trial court recognized that we were entitled to equitable subrogation. We were equitably subrogated back when that loan was paid off. That's an important point for some of their other arguments. But so we were entitled to first position up to 6.8 and no more. There's no dispute about that. So what happens was because we're now in first position, not only are we protected for the 6.8, but we're also hold the first position, and that's perhaps the most important aspect of what's protected by equitable subrogation is what position you're in, not just the dollar amounts. Because we're in first position, that we then had a right to go to a trustee sale, to foreclose, and to have a trustee sale. And what happened there was that
under the statute, and we quote we cite the statute, that in a trustee sale, the net result is that the person who gets that deed from the trustee, all subsequent liens are written off. They're gone. They don't exist anymore. And that's what we got from that trustees. When we did our foreclosure based on the 6.8, we got a deed from the trustee that said, you now have clear title. All subsequent liens are wiped out. And now, they weren't left without a remedy. They could have gone to the trustee sale and said, you know what, we think that M&I is about to get a big payoff. They're going to be able to buy this for X dollars and sell it for a lot more money. If they thought that, they could have come in and bid and protected their interests by bidding $1 more than we did, and then they would have gotten the deed and would have eliminated all subsequent liens, and of course would not have eliminated the 6.8. The 6.8 would have been paid, and then they would have been able to, get whatever windfall they saw coming out of that. But whether or not equitable subrogation applies is not determined by whether it's going to be a good deal and later on you're going to be able to sell it for more, or if you're going to lose money. That's not what equitable subrogation is determined under the restatement approach, which is what we've adopted under source court. It's determined simply by if we have in fact paid off that loan, the earlier loan, and it would result in a windfall for the second position. In this case, that's exactly what would have happened. If equitable subrogation doesn't apply here, then Hackey would have been in a position, they would have had the unearned windfall of moving up to first position. They would have then been in the driver's seat. And that would have been a windfall that they didn't earn simply by M&I paying off the first loan. And they're not prejudiced in the least by having that equitable subrogation occur, because they were in no different position. They were in a second position to the SIR mortgages before, and now they're in a second position for the same amount after the equitable subrogation occurred. What they're really complaining about is the net result of the trustee sale. If they've got a problem with what occurred in the trustee sale, then they can, if the trustee did something wrong in issuing that deed to us, that's a separate issue. They can go, file a cause of action against the trustee. But it's not the fact that after that trustee sale, we were then able to sell it for more than we bought it for in that sale. That doesn't come into the analysis of equitable subrogation at all.
What was the amount of your credit bid?
11.1, I believe.
Okay, so to protect their $186,000, they could have come in and upped the ante on your 11.1, and then they would have.
And then they could have sold it for 20 or whatever they wanted to sell it for, and then pay off the 6.8 and keep the rest.
Thank you.
So, Your Honor.
Okay, I'm still a little confused, and maybe it's my lack of clarity in mechanics liens. But it seems to me that we both agree that you were the first 6.8 million, you were entitled to that. The bank was entitled to that. I guess I guess in my mind, the mechanics lien then falls second, and then the remainder of the amount that you are owed falls behind that, the mechanics liens. And so I don't see how you get to come in, and perhaps you can explain this to me, how you get to come in and foreclose and not pay off the mechanics liens.
Because, Your Honor, what normally would happen in this trustee sale, that, again, the first question we have to analyze is, were we allowed to do the trustee sale, to foreclose because we were in the first position? That's the equitable subrogation analysis.
And we agree with that.
That's separate and apart. Now, after we're all in agreement that we're entitled to equitable subrogation, what do we get to do with that? That means we're in first position and we foreclose.
Only to the 6.8.
Correct, and I'm going to explain that. So what normally would happen is that we would be entitled to a credit bid up to 6.8, And anything above that, the trustee would normally say, you've got to pay, you got to pay cash above and beyond that. And the trustee normally would say, okay, well, anything above that, we're going to collect that, we're going to pay off, the second position, and then, so all of that would be taken care of in the foreclosure trustee sale context. But that's not what happened here. Number one, they didn't come in and they didn't bid higher. Number two, the M&I was not, the trustee did not collect from M&I any amount above its 6.8, and therefore there was no payment distributed under the statutes, the normal procedure. So again, that's why I say if we're talking about why wasn't above the 6.8, why wasn't that the money collected by the trustee and paid out under the statutory procedures, that's not an equitable subrogation issue. That is we think that the trustee did something wrong in the way he administered, and then at the end of the day, he handed us a deed which was free and clear that eliminated the lesser liens below the 6.8 lien.
So are you saying that from the 6.8 million, that the 11.1 million is paid off, only paid off that 6.8 million with what was added on with interest and?
It was a credit bid that was made by M&I, which means it wasn't actual dollars that were provided. It was a bid they were given credit for. Because they had a $6.8 million, they were owed that amount from the property, then they were given credit for that.
But how did they arrive at the 11.1?
That's a question I can't answer.
So it seems like there was about 4.3 million, assuming that the $6.8 million gets paid off. And part of that, it seems to me, I think it was 2.3 was paid by the owner to pay off the 6.8. But regardless, let's say that you subtract the 11.1 from the 6.8, you come up with about $4.3 million. And I understand that that's a credit, but wouldn't that, I'm just not following why some of that money wasn't used to pay off the mechanics liens, or why they weren't required to pay off the mechanics liens.
Because, Your Honor, there wasn't any money in the credit bid. The trustee did not actually collect money from M&I Bank, and so it simply accepted the credit bid. That was the high bid, and then the trustee then handed M&I, as a result of that trustee sale, a trustee's deed that gave them clean title. Now, whether or not that should have happened or should have happened differently is a separate and distinct issue, which really isn't the issue that's litigated here. The issue here is whether only that very first part about equitable subrogation, whether or not we were entitled to that equitable subrogation, and therefore were entitled to go to the trustee and have that sale. Once we do that, if they, again, our position is this is not a claim that they've asserted against the trustee saying you did something wrong. Maybe they shouldn't have accepted a credit bid for 11.1. Maybe it should have been limited to 6.8. And anything above that should have been paid in cash. That's not what happened here. And there is no, if they've got a cause of action against somebody for that, then they should bring that, but not come in here and say that we're not entitled to equitable subrogation. The equitable subrogation claim is, again, Your Honors, it's well established with respect to all of those cases and that we've cited. There are other arguments that say that we were required, we had title insurance. Even if equitable subrogation does apply here, then or can apply in general in concept, it shouldn't apply here given the particular facts. One of the facts they point to is that we had title insurance. Source Corp rejected that argument. They make another argument about that there's no indication, there's no evidence that we expected to be in the first position. I think the restatement very clearly rejects that argument. The restatement says, a refinancing mortgagee should be found to lack such an expectation only where there is affirmative proof that the mortgagee intended to subordinate its mortgage to the intervening interest. So in other words, the restatement says it's just the opposite standard of what they're advocating, that there needs to be some, we need to prove that we had an expectation. It's just the opposite, that the expectation is presumed to exist, that we intended to have a first position, unless there's affirmative proof to the contrary. And
Even in the face of previously recorded mechanics notices and liens. In other words, this financing was put in place after those 20-day notices were filed.
Sure. The fact that we had notice of the existence of the claim, again, that's another aspect of equitable subrogation which the restatement rejects. And so in source corp, when we say we follow the restatement approach, there is the fact that we knew when we were in third position for everything above 6.8, we knew that there were mechanics liens in position. The fact that that doesn't eliminate our right to equitable subrogation. Some states hold that. Some states say you can't. But that's not the law in Arizona, because that's not the law in the restatement. They also make an argument that as long as we had other contractual or statutory remedies that we could have used, then we shouldn't have equitable subrogation. Again, the restatement says here's what's required in order to have equitable subrogation, and that ain't one of them. That's not listed. And so therefore, we think that their argument is incorrect, that that's a requirement. I'm not going to touch on our alternative arguments with respect to the motions for summary judgment which we filed, which were denied. Actually, one was granted originally, and then the judge changed his mind. We'll rely on the briefs with respect to those. But, Your Honor, I sense that I may not have fully answered your question with respect to the trustee sale aspect of this. And if you have any other questions about that, I'm anxious to help you understand that.
Well, I guess I'm confused. I understand that it's a credit bid, but what I'm struggling with is the fact that you get credit for $4.3 million when you have prior notice of mechanics liens, and that just I'm struggling with that. I don't understand how you get credit for $4.3 million on your note that is in my mind is in second place to the mechanics liens.
We actually get credit for 6.8 because
that's not what I'm talking about. I understand that you get credit for the 6.8. You put in a credit bid of $1.1 million.
Oh, I see what you're saying, the difference.
So the difference is 4.3. So you're getting not only the 6.8, but you're getting the 4.3 credit when you have mechanics liens outstanding that certainly are in second position to the remainder of the whatever it was, 40 million minus the 6.8, whatever that is, and that's what I'm struggling with.
Yeah, no, and I understand that, Your Honor, but again, I think for purposes of the legal issues that are in front of us on this appeal, as opposed to other possible claims of how do we remedy that, in this case, we're talking about were we entitled to equitable subrogation, and I think the law is. Other than the White's decision, which I think we're going to get some clarification on, hopefully, or you're going to have to decide which of those two camps you believe is correct. But I think the law is clear in Arizona that we were entitled to equitable subrogation, and that therefore we remained in first position, and therefore we were properly entitled to go to the trustee sale. And what happened from there may or may not have been, according to Hoyle, or kosher, but it was a separate issue from the initial determination that we were entitled to equitable subrogation, to be in that first position, and there's no question about that. Thank you, Your Honor.
Thank you, Your Honor. Let me try to address the trustee sale. There was no trustee sale on a first position deed of trust. The notice of trustee sale, Record of Appeal 122, specifically is a trustee sale of the August 2006 deed of trust. That's the construction lender's deed of trust that the Arizona legislature said, unless otherwise specifically provided, mechanics liens are preferred to all other liens, like the bank's deed of trust. Unless otherwise specifically provided, mechanics liens are preferred to all other liens. When the legislature gives you here's what they are preferred to all other liens, and then they give you that exception, they have stated their intent as to what they meant. And they didn't mean, oh, by the way, let's give construction lenders one more exception. We gave them the 10-day grace period. That's what was given to them in 1998. They could have asked for more. They only got that. Let me quote Smith v. Brimson, an Arizona Supreme Court decision in 1938. The maxim, he who comes into equity must come with clean hands, means whenever a party who, as actor, seeks to set the judicial machinery in motion and obtain some remedy, has violated conscious or good faith or other equitable principle in his prior conduct, then the doors of the court will be shut against him in limine. The court will refuse to interfere on his behalf, to acknowledge his right, or to award him any remedy. That's what happened here. The notice of trustee sale and the trustee's deed, which is Record of Appeal 137, specifically involves the 2006 deed of trust that's in second position. There's no warranties that it was that they foreclosed any mechanics lien or anything like that. I don't know what he's saying. A trustee's deed has no warranties whatsoever. It says, here, you got what you got, but we don't tell you what you got. And that's exactly what they received. They foreclosed their second position deed of trust. That's why they could make an $11.1 million credit bid, because they were foreclosing their second position deed of trust. ARS Section 33801 says you can never make a credit bid for more than the balance owed. If they were foreclosing the SIR mortgage deed of trust, they could never have made what was still owed under the SIR mortgage loan, which was either $6.8 million, or if you apply the $4.5 million they received already from prior sales, or the $2 million that the owner paid, is less than that. But it was never more than that.
How was the 11.1 arrived at?
Oh, Your Honor, they were foreclosing a second position lien against property worth $20 million, subject to a bunch of other liens. What's the value of a second position deed of trust against property worth $20 million, subject to a bunch of other liens? About $11 million.
It's not based upon their $6 million infusion into this.
Oh, it has
SIR
nothing to do
mortgage
with
debts.
that. That had nothing to do with that. That's why they didn't even mention equitable subrogation until, a year later in the motion for summary judgment. And the theory that equity stops once they get their lien and they could secretly foreclose a SIR mortgage deed of trust without telling anybody, we were prejudiced. If it was a SIR mortgage deed of trust being foreclosed, we could have outbid them at $6.8 million or some lesser amount. But no, they come in with a credit bid of $11 million just to mess with the mechanics lien claimants so they can't outbid them. Well, that's prejudice. And when there's prejudice, you don't get equity. And that's why I cited Smith v. Brimson when I started. I've run out of time.
Okay.
I'm happy to stay longer if you'd like me to.
Anybody else? Thank you very much. We will take the matter under advisement and issue a ruling in due course. We're going to recess a little bit so that these folks can leave and the next folks come forward. So, thank you.